My lords, if we could pick up the judgment again, that's where we were. If we could pick it up at page 108, I think we've dealt with the main issue back and forth, but there are just a couple of other points I did want to show you. So it's page 108 of the core bundle. So on that page, what the tribunal does is it reproduces the passage from Lord Sale's judgment in Packard that my Lord the Chancellor referred to earlier, but we hadn't looked at yet. Yeah. Which is the bit where it actually does talk about whether something is a DPA in the sense that we're discussing here, about whether it's a payment that's determined by reference to the amount of the financial benefit. So the particular argument that was being dealt with here in paragraph 98, you can see it from the bottom 5 lines of that paragraph, was that it's the tribunal's discretion, not the percentage of damages that was specified in the contract, that ultimately determines the amount of the funder's fee. And so because of that, and because the contract actually made reference to that and provided for it, the position was that it was no longer an agreement that provided for the payment to be determined by way of reference to the financial benefit. It would be determined by reference to whatever the tribunal thinks fit. That was the argument. And in paragraph 99, Lord Sales rejects that argument. He says that none of that affects the application of section 58 AA3. The LFA provides that payment of the funder's fee is conditional on UKTC, because UKTC was the opt-out one, receiving a specified financial benefit in the litigation. The payment to be made is obviously a success fee. As the appellants submit, the fact that a claims management service provider enters into an agreement, here's the relevant bit, which adds a further condition which must be met before a payment is due, does not deprive the remuneration being of the character of a specified financial benefit within the meaning of section 58A 3A1. This is a general point which has particular force, where, as here, the additional condition simply reflects the mechanism in the tribunal rules which allows for such a payment to be made. And then, sorry, this is the most relevant bit. It says, it also remains the case that the amount of the payment due to Yarcombe is to be determined by reference to the amount of the financial benefit obtained, so as to satisfy the condition in Roman 2 as well, even though the structure of the opt-out regime, according to the Competition Act and the tribunal rules, means that this is treated as capable of being departed from in certain circumstances. So the point that's being made there.
You read the next sentence.
I was going on to the next sentence.
The next sentence is, you apply that in the present case, it's against you, isn't it?
Well,
the primary contractual entitlement is to a payment determined in accordance with the amount of the outlay with an uplift.
I'm coming on.
In certain circumstances, something else may be payable.
I'm coming on to that, so I'll take it one sentence at a time. I wasn't going to skip over it.
I know you wouldn't, Mr.
No. Dealing with the first sentence first, in my submission, what's being said here is that because the contract does provide for a payment to be calculated and determined by reference to the financial benefit in some circumstances, it doesn't matter that in other circumstances those will be departed from. And
that's not what it says, is it? It's talking about circumstances outside the contract. It's not talking about terms of the contract in the sentence you're referring to.
No, so that's why I did want you to look at the last 5 sentences of paragraph 98 as well, because the terms of the opt-out LFA were structured to take that mechanism into account. Clause 10.1 imposes an obligation to pay the funder's fee, save, so this is the contractual language, not the wording of the rules, save to the extent that the aggregate amount ordered by the tribunal is less than that, so it's capped.
Right. The sentence you draw attention to doesn't talk about that. It talks about the opt-out regime according to the Competition Act and the tribunal.
That's true, my lord. And my submission is that when you read these 2 paragraphs together, it can't be that Lord Sales has forgotten that the contract actually provides for it as well. He treats, in the previous sentence, he treats the fact that the rules provide for this as an a fortiori reason why it's irrelevant. But what he's saying here, in my submission, is that the fact that the contract has made provision for a payment payment by reference, determined by reference to the amount of the financial benefit, isn't changed by the fact that the contract also, and the rules also, provide for that to be departed from in some other circumstances, so that the ultimate outcome, you know, to use the word that your lordships didn't use with me, but it's what you were getting at, that the ultimate outcome in a particular case might not be a percentage of damages at all. The ultimate outcome in the UKTC case, if it had never gone anywhere, might have been just an amount plucked out of the air very judiciously by the tribunal. And Lord Sales says it doesn't matter. The contract is still one that does provide for payment by reference to the amount of damages. Now, it's true, my Lord, the Chancellor is right, and the tribunal noted this as well, that it's true that Lord Sales goes on to say that Yarkham's primary contractual entitlement is to payment of an amount determined by reference to the proceeds, even if there may be a departure from that. And in my submission, that contract that was at issue in UKTC, it is a rare situation where you can understand what is meant by the expression a primary obligation. Because the only circumstance where something else will be paid is where the tribunal orders that the amount should be different from the amount that the number that the parties had actually agreed on. But in my submission, Lord Sales was not laying down some kind of test that calls for the making of this kind of distinction in every case. His Lordship went on to say as well, and this is another point against me, my Lord, that the LFA retains the character of a DBA, and we'll see that's what the tribunal latches onto. But it says the character of the DBA as defined, and that in my submission is the key term, which is entirely consistent with our case, which is that it retains the character of a DBA as defined, because it does provide a mechanism for determining the payment by reference to proceeds. And if you go on to read the next sentence after that, so after the as a matter of substance one, he says, it is inherent in any DBA that risk is shared by the funder. So the fact that under the opt-out LFA, Yarkham as funder shares the financial risks associated with the litigation provides no basis to say that this LFA falls outside the statutory definition of the DBA. And exactly the same can be said in our case. In all of the cases that I'm addressing you on today, that the funder shares the risk relating to the amount of damages in each of these cases, because a small damages award in any of them would lead to a smaller payment being made to the funder using the single mechanism for determination that is actually set out in these contracts, which is the lesser of mechanism. So that's what I say about that passage from Lord Sales. It supports our case. The tribunal disagreed. So in paragraph 66, you can see it latched on to Lord Sales' reference to the substance of the character of the LFA and divorced it from what Lord Sales actually said about that character, which is
67 is really the critical paragraph, isn't it?
67.
67, it's where they say that the arrangements are firmly and primarily based on the determination of the funder's fee by reference to a multiple of outlay by the funder, not by reference to sharing a percentage. And then they say that the fact that other factors might lead to a different result doesn't change the analysis. So
that's right, my Lord.
they're turning it. I mean, your everything you say about the last 2 or 3 sentences of 99, Lord Sales, is really being dealt with here in reverse. I mean, that last sentence, for example, of 99.
Yes, but
what that's saying is the fact that the funder shares in the financial risk doesn't turn what was otherwise a DBA into a DBA. What you're saying is the fact that on your case, the funder shares in the financial risk turns what isn't a DBA into a DBA, which isn't what Lord Sales was addressing at all. He was addressing the reverse.
Well, it's true that Lord Sales was addressing the reverse, but in my submission, what the tribunal does here, reversing his logic, reverses the force of it as well. And it's not right that my submission is that the fact that there's risk sharing turns something into a DBA when it otherwise wasn't. We've got one agreement in front of us. I think I know what your lordship means, which is counterfactually
If it weren't for the cap,
If it weren't for the cap, well,
DBA.
then I do understand your lordship, and that's right. But it's entirely consistent with the logic
Whereas
of what,
Lord Sales are dealing with a situation where,
with a different situation.
but for the contingency, it was a DBA.
That's right.
You're dealing with a case, you have to address a case where, unless you're right about the contingency, it is not a DBA.
Yes, I understand now, and your lordship is absolutely right in that analysis.
Yeah.
Of course. So I wasn't submitting, and I didn't intend to submit, that Lord Sales has actually dealt with the case in.
No, I didn't think you did. You weren't
then-
being critical, but you
No.
really.
But what I do submit is that the logic of what Lord Sales is saying supports my position, which is that once you have an agreement that does expose the funder to that kind of risk sharing, and it's the agreement, it's not other contingencies that are outside the agreement that are doing it. The agreement exposes the funder's payment to the risk of going up or down depending on what the damages are. If the character of a DBA is going to mean anything, and that's what Lord Sales is referring to, that's what it means. That's entirely consistent with my reading of the Act, which is that once you've got a mechanism that makes you refer to the damages, it does something with the damages in order to determine what the level of the payment is, bang, that's a DBA.
And it would follow from that if the contract said the funder will be paid in the event that there is an award of damages, brackets, even if nominal, 10 pence, that would be a DBA.
My lord, no. It depends what the... So I can give you an example, which I think will illustrate why
Isn't
not.
that dependent upon an award?
No. If we go back to the Act, and I can show you. Suppose you've got let's go back to the Act. So it's in Authorities Bundle, page 27. Let's suppose that you've got an LFA, or indeed a solicitor's retainer. It's easier if we just make it an LFA. Don't bring in the rest of professional conduct rules, etc. So we've got an LFA that says, in the event that the damages award is greater than £500 million, then the class representative needs to make a payment, and the amount of the payment is some number, which is less than £500 million. In that situation, just looking at the Act, section 58AA3A1 is satisfied. So it is the case that the recipient is to make a payment if the recipient obtains a specified financial benefit. So that's more than £500 million.
Or more than zero.
Or more than zero, yeah.
No, well, in the example I've just given you, the example I gave was the threshold is £500 million. So that's the way the specified financial benefit would be in that LFA. So we've satisfied Roman 1, but we haven't satisfied Roman 2 because the amount that needs to be paid is £400 million, and it's £400 million whether the damages turn out to be 1 billion or 2 billion or 3 billion or 4 billion. It's always, the payment, if there is one, is always the same. Now, in that circumstance, you've satisfied Roman 1, but you haven't satisfied Roman 2 because the payment doesn't depend. It doesn't depend in any way on the amount of
What if we
damages.
said the complete opposite, that the payment depends on whether it's bigger or smaller than 500? So why do you move the contingent? Just because the Act has split the logic into two parts, you've been spending the morning telling us you don't split the logic up, you look at it as a whole. So why do you suddenly now split it up?
No, you do read it as a whole. I'm describing an entirely different type of LFA, which would be, I'm not saying it's a good idea, but it would be, just to answer my lord's point, just to illustrate that you can have agreements which will never result in you paying out more than the damages, but they're not. It's not achieved through a cap by reference to the amount of damages.
But it is. But the amount that you get is determined by the amount of the damages,
That's true.
which is exactly what
It's exactly
your
the same.
construction of little 2 is.
It's just another way. If you're right about little Roman 2, Which is another way of putting the same point.
Well, my submission is no, because the amount that's payable is fixed. It never changes. It's
It
always.
isn't fixed, it's
Still
either zero
is.
or it's
Zero
Yeah.
or X.
zero. What's
It's still determined on your case by reference to the amount of the financial benefit.
Well, I can see that alternative way of reading it.
'Cause it's
That's
zero.
not the way I'd read it. It probably doesn't matter for today's purposes. But if that's the way to read it, then the answer to my Lord Justice Green's question is yes.
Yeah.
If that's the way you read it.
It's a DBA and it's unlawful.
No, it's only unlawful if it doesn't comply with the requirements in the DVA regulations.
It's unlawful in opt-out proceedings.
Sorry.
Opt-out proceedings.
And in opt-out proceedings, of course, but that's because of an entirely different enactment.
Yes.
That's right. So that's where we are.
If we give one, since we're on examples, can I ask you an example? So
Sorry, my lord.
let me just put another question to you, Mr. Bishop.
Yes, of course.
There's a lawyer and an impecunious client,
Yes.
and the lawyer says, if we win and the defendant pays our recoverable costs, I will take the irrecoverable costs from your damages. Now that is pretty commonplace. Whether it's written down, it's pretty commonplace.
Right. Then
That, on your construction, is a DBA. Because if the client's impecunious, the damages, if they're lower than the irrecoverable costs, then the damages are the limit.
I think I haven't thought about that example, but that sounds right, my lord. Yes.
Well, it matters to me, I mean, do think about it, because that wasn't champity before this law came
I
into
see.
force.
So the contract provides
As
that.
my lord says, that's an absolutely standard. Whether
So
it's
the-
ever written down is another matter,
Right,
but I mean, in terms of commercial reality of relationship between clients
Oh,
and
well-
solicitors, that's a standard arrangement.
Well, my lord, there's a difficulty here, which is that if it's not written down, so if it's not actually.
Oh, well, let's
assume
it's written down.
Assume it's written down.
But no, it is.
Get out of it that easy.
No. Not trying to get out of it, but I do want you to have my submission, which I made earlier, that in situations where it's just practical reality or forbearance, then it's not caught, and we've seen that in the CFA context. And so whether you write it down or not makes a difference to whether it's lawful or not. That is right. But the contract you have in mind is one in which you say that if we succeed, that the fee will be.
Well, no, the costs will be whatever they are.
The costs are whatever they are.
I'm going to get my recoverable costs, my taxed costs, to use the old expression, from the other party,
Yes.
and there's still my irrecoverable costs.
Yes.
I'm going
And
to collect them out of your damages. And so if your damages are lower than my irrecoverable costs, then that's the limit of what I'm
Yes,
going to
well,
get, because you're impecunious, and that's the line.
yes, if that's what we've agreed in the contract, then I
That's
can't
a
see a way
DBA.
around that.
It feels like a DBA on your case, Mr.
Yes, my lord, I think you're right. That's right. And so that would be another one of these situations where, because you've gone about regulating in this way, you produce that kind of result. It's similar to the situation where, with CFA regulation, if you, it used to be the case if you agreed with your client that you would only charge them costs in the event that you succeed, then that turned it into a CFA, and if it didn't comply with the regulations, then it was unlawful. It still is the situation. Sorry, I shouldn't be putting that in the past tense. That is the law. Like that is the effect of Section 58 of the same act that we've been looking at. I'm not sure it helps us one way or the other in the end. So we say that the tribunal's reasoning that we've just been looking at was wrong. I think in passing, I've dealt with most of my learned friends' points about it as well, which are along similar lines. There's one other point that I haven't fully addressed, I think, which is their respondents' notice point. So this argument is based on the provisions relating to CFAs that we looked at earlier, and that was the reason why I showed you the provisions relating to CFAs. If I can just show you in the skeleton argument, it's at page 432. and it's you can pick it up from paragraph 58.2. So here they remind us that if you have a CFA in a personal injury case, it has to be capped at 25% of the damages. So it will provide for a payment of whichever is lower out of the multiple of costs and 25% of the damages. And they say that on our analysis, such a CFA would also be a DBA, and that's right. That's what we say. And on that basis, it meets both of the statutory definitions. Neither of them is expressed to be exclusive of the other. They're both, if these conditions are satisfied, you are a CFA or DBA. And so you need to comply with both sets of regulations. And one consequence of that is that it means that you need to explain on the face of the agreement why you've chosen the particular damages percentage that you've chosen. And my learned friends say at the end of para 58.3 that this would be odd because the reason why the lawyer in question has chosen a cap of 25% is because that's what the legislation requires. But my answer to that is that that's wrong. The legislation requires you to impose a cap by reference to damages and says that the cap can't be any higher than that. But you can, of course, have a lower cap. And so you just need to explain why you've done what you've done. It's no different from any other DBA. In 58.4, they make a further detailed point, which is that in the CFA context, you can get the success fee on top of your recovery costs, whereas in the DBA context, the damages payment needs to include recovery costs. Like all you can recover is the 25%. But again, there's no inconsistency between the regulations. It's perfectly possible to comply with them both, and that's what we say. But ultimately, this whole line of argument can't take them anywhere, because as I said at the start, the exercise we're supposed to be doing here is construing section 58AA by reference to the policy and context at the time it was enacted, which is before any of these regulations, either DBA 13 regulations or the CFA order from 2013, before either of those came in.
What if the facts were these? What if, let's assume that you're right about what DBA means at the time it was enacted in the Employment Tribunal.
Yes.
But I'm putting it in crude terms, let's jump forward a few years to the Courts and Legal Services Act, and let's assume, and I know you don't accept this, I'm not trying to make you say you do, that Parliament thought that a DBA was narrower and was like the appellants say, and enacted on that basis. Imagine you could know that, and I appreciate you might say you can't, but let's say the correct conclusion, looking at all the material, is that at the time this was brought in, it was understood that DBAs meant something different from what they meant when they were originally used. And let's assume you were able to reach those conclusions. Are we supposed to do nothing about that, or shouldn't we be construing the Act we have based on the context in which it was brought in, on the basis of what Parliament thought they meant they were doing when they used the language they used?
So, my lord, I think if what you're referring to is the changes that were made to section 58AA in 2013, so if you're saying that those changes make clear that Parliament meant a narrower definition of DBA all along, then I think that takes you into the bit of Lord Sales's judgment in Packard that we debated much earlier, where you pointed out that he wasn't deciding the issue. And so I think if the facts are as you put them to me,
Yes.
I can see the force of the argument that you're making. But it does need to be the primary legislation, because I think once you get to the secondary legislation, you're squarely in the territory that Lord Sales ruled out. So I hope that's a fair answer to your question.
Yeah.
That takes me on. I was going to show you all of the other agreements, but I think in the interest of time, I'm not going to show you any of the other agreements. The position is exactly as the Chancellor put to me earlier, that the difference between them is that they've got implied caps instead of express caps. A cap is a cap.
We only need to look for present purposes at the one, don't we?
In my submission, yes. So that takes me on to issue 2. Issue 2 is specific to just 2 of the cases, CRCC and Neill, because in those cases, but not the others, the class representative has agreed for, I should say in Neill it's the class representative who's agreed this, in CRCC it's actually the solicitor who's agreed it, but
Yeah.
don't worry about that. they've agreed for a percentage of the proceeds to be paid to the funder. So it is then a percentage again, but only to the extent that that's enforceable and permitted by applicable law. And so I'll show you the particular wording in a moment. But the gist of it is that the class rep has agreed now that if the law changes in the future, before you get a judgment, I suppose, then they will pay a percentage of the proceeds. So that gives rise to an additional issue beyond issue 1. So in other words, even if I'm wrong at issue 1, we still have a beef with these clauses.
This is common ground as I understand it, that without the caveat about if it's enforceable, then it would be a DBA.
Then it would be a DBA, exactly, that's right.
Not necessarily.
Yes, and I will just show you, let's just look at the Neill one. So that is in the supplemental bundle at page 358, so tab C3. 358, yes.
358.
358. That's just the front page, but if we just skip on to page 375.
Yeah.
And there's clause 11.1, which deals with the situation where the funder gets paid ahead of the class, because just like in Gutmann, this is one of those agreements that provides for both possibilities. One possibility is they get paid ahead of the class. The other is that they get paid behind the class. And what's interesting here is that what's been provided is that they will get paid the greater of, see that wording at the end of the main body, greater of the multiple of the cost limit, or, and then 11.2, only to the extent enforceable and permitted by applicable law, a percentage of the proceeds. Just pausing there, I'm slightly unclear as to, I mean, it has been conceded, and rightly so, I agree with the concession that this is a DBA, subject to the qualifier. But it is one where it's another mechanism. This one's the maximum value function, where they say, I'll take the greater of something that's not the proceeds, it's a multiple, and something that is the proceeds, which is the percentage of the proceeds. And the way I analyze that is very straightforward, which is to say that that single mechanism, you take the greater of the two, is a mechanism that requires you to look at the value of the proceeds. I don't really know why my learned friends accept that that is a DBA, but they do. What we're here to debate in issue 2, though, is just that wording only to the extent enforceable and permitted by applicable law. I should just say for completeness that they have similar wording down at the bottom of page 376 under 11.2 for the other situation, which is where payment comes after the class. The question, as I've said, is whether the words only to the extent enforceable and permitted by applicable law save this agreement from being a DBA. We say no. Putting aside questions of severance, which, as I've said, my learned friend, Ms. Sarathi, will address you on shortly, we say that this is an agreement that provides for the amount of the payment to be determined by reference to the amount of financial benefit. It's an agreement that says, if certain matters come to pass, the class representative must pay the funder a percentage of the damages. Those certain matters are: 1, the claim must succeed; 2, the percentage of damages must be larger than the multiple of costs; and 3, the law must have changed to permit class representatives to make agreements that provide for the payment to be determined in this way. But notwithstanding those contingencies, we say it is still an agreement that meets the definition because it provides for the payments to be determined that way, albeit only in those circumstances. So that's a textual argument which is of the same flavour as the textual argument I was giving you before in relation to issue 1. I read the words of the Act in the same way in all parts of my argument. The main response to this seems to me to be the policy argument, and I'll show it to you in the tribunal's judgment in the Neill case. So if we pick that up at 231 in the core bundle, sorry, just checking. So it's core B6.
Isn't the answer to it that unless and until the law changes, it's nihil ad rem in Latin,
No,
of no contractual effect. It's just of no contractual effect.
my lord,
Because it only applies if and to the extent that the law permits, and at the moment, as everybody knows, the law doesn't permit. So it just doesn't have any effect at all.
but it is different from a situation in which the class representative had not agreed those words and just thought that they'd wait, and if the law
Maybe
changes.
different from, in the sense that in another form of agreement, those words aren't there. But if the words don't have any contractual effect, it doesn't really make much
No,
difference.
but when I said they're different, my lord, what I meant by that is that the rights and obligations of the parties are different. So it does have contractual
The
effect.
parties haven't got any rights and obligations under this provision
But, my
unless
lord-
until the law changes.
My lord, they do, in the sense that if the law changes, they're stuck with those words. So they've agreed now what the position will be in that contingency.
So the way to interpret it now is that the parties implicitly accept that that second condition, the alternative, is not in place. It's not something which arises because it would be unlawful. Therefore, the correct way to interpret it is slightly clumsy, but from undistributed, funder's fee shall be the greater of a multiple of the cost limit, full stop. In other words, it's the cost limit. Because the second part of it is just everybody accepts, the parties have understood, agreed and acknowledged that that cannot at the moment be the case. So you just interpret the contract, given the point in time that we are at, as if the second part of that clause 11.1 doesn't exist.
That's right. And if the law doesn't change and we get to the end of the case, then I think we all agree that the way to apply this clause is exactly as your lordship has just said, and it will
This is
produce.
your case on conditions, isn't it? Sorry. This is just your case on conditions. You say it doesn't matter if there are conditions precedent. There is one here, it's a condition, doesn't matter what kind it is, it still makes it a DBA, because if something has prior conditions, they're still DBA if...
That is my
That's your
submission.
argument.
That is my
Condition
argument.
subsequent.
Yeah. That is exactly my argument, my lord. And then if you look at what the tribunal said about that in paras 147 to 148, I'll just read it quickly because it is effectively what the Chancellor just put to me.
Which is where,
So on page 231 of the core bundle.
231. Yeah, it's 18448, isn't it?
But my submission is that is not grounded in the words of the Act. I mean, the words of the Act ask what the agreement provides for. That's why I was emphasising provides for. And the Act does provide, as Lord Justice Burst put to me, summarising my argument better than I put it earlier, that the Act does provide for the determination by reference to the amount of the proceeds, albeit only if the law changes.
When you think of a policy objective,
Exactly.
why this should be objectionable.
Yes, that's where I was coming. Because as I said, this answer that is put to us here is effectively that. So, in my submission, the tribunal's reasoning here gives rise to a number of problems. One is, suppose that the law changes not by reversing PACA, but by repealing section 47C8 of the Competition Act, such that DBAs become lawful in opt-out claims. That's one way that it could happen, and actually that is one recommendation amongst others that the Civil Justice Council has just made. If that happens, does a funding agreement with this kind of wording suddenly become a DBA or not? Does the question of whether it becomes a DBA depend on whether, if it does become a DBA, its terms are such that it would then comply with the provisions of the DBA regulations, including the percentage cap and including the explanation that are given? It's just, it becomes quite quite headache-inducing, or at least my simple mind finds it headache-inducing, to answer the question of whether in that circumstance it is a DBA or isn't. Because if it is, it doesn't comply with the requirements of the regulations, because they don't give us an explanation as to why they've found the level of the cap. But if you need to contingently apply the substantive provisions of the regulations to figure out whether the substantive provisions of the regulations apply to it in the first place, you're just running around in circles. That's why this whole strategy of interpreting.
Okay, it's bloody complex. Why is it bad policy?
Yes, that's where I was going next. Sorry, I should have answered that question first, my lord.
There's lots of complex things that you and everybody in this room deals with in this area on a daily basis.
Yes. So I think it might be helpful to look at the policy that was behind Section 47C8 of the Competition Act as well. So that's in the supplementary authorities bundle that was provided yesterday. And it's at tab B2 of that, which is at page 93. And if we go forward to page 119, so this was when the government was consulting on what it should do in terms of changing the collective action regime. And you can see there's a heading, opt-in or opt-out. And there follows some pages that's setting out the responses to the consultation from various consultees and what they argued. If you go on to page 122, you've got the heading, the government's decision. And at 511, the government acknowledges the strong and passionately held views on both sides, recognises the concerns of respondents who worry about frivolous cases, and the government says it's got no wish to introduce a regime that would create a litigation culture. And then at 512, the government says, however, the existing system doesn't work, we need an opt-out regime. And then at 513, says that they firmly agree that strong safeguards are needed. Over the page you can see what they are: certification, limited jurisdiction, no contingency fees, no treble damages, that kind of thing. And it's the no contingency fees that I want to focus on for the moment. So there's more detail of that on page 133. At 562 to 563, where the government says, prohibiting the use of damages-based agreements, sometimes called contingency fees, was one of the key safeguards highlighted by many respondents as necessary to ensure that an opt-out collective actions regime did not lead to a litigation culture. The government agrees that this prohibition would be an important safeguard, and that allowing DBAs could encourage speculative litigation, thereby placing unjustified costs on defendant businesses and creating an incentive for lawyers to focus only on the largest cases. No win, no fee conditional fee agreements, and after the event insurance will remain available for the use in these cases, subject to the changes in the LASPO Act. The government has therefore decided to prohibit DBAs in collective actions in the CAP. So Parliament deliberately banned DBAs for opt-out litigation to avoid a litigation culture developing. It wanted to avoid speculative litigation, avoid encouraging speculative litigation, and to avoid incentivizing lawyers to focus only on the largest cases. And my submission is that all three aspects of that policy relate to the creation of incentives arising from a link between the size of the damages and the payment to the service provider, in a paradigm case, the lawyers. And as to why this is a bad thing, I say that clauses of the type that we can see in Neill create those incentives immediately, right now, today. So think about a law firm, because if my learned friends are right in relation to an LFA, they're also right in relation to Hausfeld, just to pick one. I don't mean to pick on them. So think about Hausfeld, that they could, right now, enter a retainer with could cut out the middleman, don't need funders, enter into a retainer with a payment structure of the kind that is used in Neill. And on their submission, that's not a DBA. So a law firm that's read the Civil Justice Council's report and can see that one possibility is that section 47C8.
Well, that's as maybe, but we're concerned with litigation funding agreements with litigation funders, not with CFAs with solicitors.
But my lord, that's why I said at the
The
start.
primary way in which it's intended, as I understand the CJC report, the primary way in which it's intended to redress the concern that's arisen as a result of PACAR
Your lordship is right.
is by
Repealing it, like overturning it. Yeah.
by making it clear that claims management services don't include litigation funders, or possibly with the enactment eventually of section 58B of the 1990 Act. But I mean, if that's right, then
Then through that
they wouldn't
route,
be they wouldn't be DBAs because they wouldn't fall within section 58A.
your lordship is right. That would be another legislative solution. My submission to you today is that you need to be quite careful trying to fix this for yourselves instead of letting Parliament
That's
fix
all.
it.
This particular contingency, to the extent allowed by law, that's what that's contemplating, isn't it?
Well, my lord, no. See, this is the problem because the argument
Sorry,
that's being
does it matter? I asked you what the policy behind why the clause was bad.
yes.
You've explained why DBAs are bad, but if Parliament alters its position and says that this particular type of disputed clause is okay, then by definition, it's not bad for policy. Because Parliament's now said, okay, we accept it.
I think, to be fair, your point, Mr. Pitcher, is that by putting that clause in, the incentive starts working today,
Correct.
even if the law doesn't change. That's the point you're making.
My lord, yes, and the last thing you said, even if the law doesn't change, I think that's the way
Yes.
you put it, is my answer to my Lord Justice Green. Because this is the error in the tribunal's analysis. They say, what if the law changes? Well, if the law changes, it's fine. Nothing's gone wrong. I absolutely agree with that.
But
what
what
if-
difference does it make if the law doesn't change?
If the law doesn't change and Hausfeld enters into a contract of this type today, then it will already be the case that they have the very types of incentives that Parliament legislated to prevent. So they will.
But with respect, an incentive that completely meaningless because on this hypothesis the law never changes. So
But-
that, it's like cutting off your nose to spite your face.
My Lord, I'm afraid not, because the position is that the law might change. We are presently in a state of uncertainty as to whether the law will change or won't change. Both are possible. It's possible that Parliament will read the Civil Justice Council's report, so that's very interesting, but that's not what we're going to do.
Well, that's of course possible. Parliament, having waited for the Civil Justice Council report and said the government, having said that's what they're going to do, may decide they don't want to do anything after all.
Well,
That's
once they've read
possible.
it, yes.
In which case, none of this will ever happen.
Fine,
I mean, all this is doing
No,
is,
but
this is just
my Lord,
a-
no,
this
that
is
last
just a-
point is wrong.
No,
So,
this is just a way of avoiding the fact that if the law does change, if that weren't there and the law does change and people want to enter into LFAs on a percentage basis, percentage of damages
Yes.
recovery basis, they will have to enter into yet another revised LFA. And all this is doing is avoiding the cost and the time that will take into entering into yet another agreement and saying, well, in the event that Parliament changes the law, then we can go back to the system that we were under previously. That's all it's saying.
but my Lord, I'm afraid not, because it does more than that. It creates the incentives. It gives you now access to the incentives that Parliament said you shouldn't have.
Well, I just don't understand. I'm
Be-
sorry, I
be-
simply
because-
don't understand that. at
Because
all.
right now, if you're a law firm who is looking at taking on a case, and you need to ask yourself, well, how much time is it going to involve? How much cost am I going to
Well,
incur?
how does this incentive point of yours work? If in fact, I mean, we all know that if Parliament does change, does reverse PACAR, that a number of litigation funders are going to say, well, I want to go back to where we were previously. And I mean, there is a school of thought that says actually that damages-based LFAs are a lot better for the
Yes.
the consumer than what we've got instead. So
No,
they will
yes.
want to go back to it. If this weren't here, they'd simply say, they'd be saying to themselves, we'll have to enter into yet another revised LFA.
Yes.
And your incentive point applies equally if that's the position, because they're thinking to themselves, well, with a bit of luck,
My incentive
that's what's
point,
going to happen.
but my incentive point only has teeth. It only really works, as Lord Justice Burst said, because of the possibility that the law won't change. If you're assuming that the law is definitely going to change, then I agree with you. The only effect of the agreements is to bring it forward and save
If
costs.
the law doesn't change, then what incentive
But
for what?
because, my lord, this is what I was trying to explain to you, to just explain before, that right now, if you're a law firm assessing whether or not to take on a new case, you weigh up the costs and the benefits. And on the benefits column, one of the things that will be motivating your decisions about which cases to pursue and which cases not to pursue will be the possibility that the law will change. And if it does, then you will get a share of the damages.
Yeah, well, that's fine.
Why is that a problem?
Well, it's a problem at the moment. It's because Parliament has said that what that does is it creates encouragement for speculative claims, and because it encourages you to focus on the ones that have the highest value. And Parliament has said in the consultation response we were just reading that and this is why they enacted Section 47 C8, that they don't like that. There are arguments to the contrary. You might say, my lord, I'm delighted to encourage speculative litigation. I'm delighted to encourage US-style outcomes where people, get paid sums of money that allow them to buy yachts or jets.
I understand the submission. It's a submission without evidence.
No, it isn't, because it's a submission by reference to...
You're assuming that the structure of the agreement that we've seen,
Yes.
if replicated without legislative intervention, will generate amongst funders and solicitors a desire to take on litigation which is undesirable in the public interest, not just higher risk, but undesirable in the public interest. And that's a nuanced submission which I think would require some evidence.
My lord, no.
Not just higher risk.
No, because the bit about it being undesirable, or about those incentives being undesirable, I take from the consultation response.
That was a general statement about undesirable excessive risk litigation.
Speculative. It's not about the level of risk.
Speculative. All litigation has a degree of speculation.
That's right, but
We're talking about gradations.
But, my lord, with respect to coming dangerously close to saying that Parliament was wrong in the policy judgment that it made.
I'm saying that you haven't established that the level of risk, the heightened level of risk that would be accepted by litigation funders, be they solicitors or finance houses, would get to the level at which it would be contrary to the public interest.
My lord, it's exactly the same set of incentives as you get under a DBA. If you just delete the word "safe to the extent," it's in no circumstances it's exactly the same set of incentives, which is that you know that there is in a contingency, if things go well for you, you'll get a share of the
I
damages.
understand the argument. I can see how.
I still don't understand how it's different from the situation, which is, after all, in one sense, the situation we're in right now, where if relevant firm solicitors is, I don't think it's appropriate to identify names, but a relevant firm solicitors is sitting down with a client thinking, or with a potential class representative thinking, shall we enter into CFAs and LFAs? And they enter into this form of agreement on the one hand. On the other hand, they say, well, Parliament may change the law, in which case we'll have to have another amended agreement in due course. And they both got that in mind as a distinct possibility if the law is changed. I just don't, for the life of me, see what the difference is in terms of your alleged incentive between the first one, which you say renders this into an unenforceable DBA, and the second one, which is actually just bearing in mind that you might want to enter into an amended agreement in certain eventualities.
The difference is that in one case, it's a hope as to something you might do if the law changes, and that you might not be able to negotiate with your client at that point, because the client at that point might say, why am I going to give away 30% of my damages, having seen how the case has developed? That's why there's a difference. The difference that is made is that you're already bound in now to these terms. That's the difference. But those are my submissions on issue 2. I do need to hand over to my learned friend to deal with issue 3, which is severance. But before I do that, I did just want to make one final point in relation to the AT insurance policies. These don't give rise to any different issues under section 58 AA3 A2. But there is an additional point that was taken below, didn't result in any judgment and then has been taken again in skeleton argument from my learned friends to the effect that ATE policies are not claims management services at all.
Is that issue before us? It's not one of the issues
Well,
on appeal, is it?
I say it's not.
It's not.
That's my position.
It's
my
not
lord.
one of the.
It-
It's
there-
not
there-
one of
there
the
should have
issues
been-
in the judgment. So
no,
it's not.
there-
It's not
there-
full call.
There should have been a respondent's notice, and there wasn't. So I'll deal with that in reply if I really need
Well,
to.
if there's anything in it,
If
deal
there's
with
anything to
it.
say. But otherwise, I will hand over to my learned friend.
Thank you. Thanks very much, Mr. Commissioner. Yes. Severance. Mr. Rothie.
Yes, I'm addressing your lordships on issue 3, severance. I propose to structure my submissions by first dealing with my learned friend's preliminary point that this is not an issue about severance at all, but rather, as they put it, locating the limits of the DBA within the broader confines of the LFA. Second, dealing with the key case on severance, this court's judgment in Volterra. Third, explaining why, in the case of the Sony LFA, that test is not satisfied. And pausing here, the issue only arises in respect of the Sony LFA, and only insofar as your lordships find that the percentage payment provision is an unenforceable DBA. The respondents in Mastercard and Visa have not sought to assert in this court or below that the similar provision in their opt-out priorities agreement is severable. Finally, I intend to deal with the judgment below and the remaining points raised in my learned friend's skeleton. The respondents rely on this court's judgment in Zuberi and Lex law for the proposition that only the percentage payment provision constitutes the DBA, and only that is unenforceable without affecting the remainder of the LFA. So, they say, this court doesn't need to get into severance at all, and that is in their skeleton at 86 to 87. This is not a point that was addressed by the tribunal, and the respondents haven't filed a respondent's notice seeking to uphold the decision on this additional ground. But in any event, we say that my learned friend's interpretation of Zuberi is wrong. The case is at Authorities Bundle 3B20, starting at page 863.
Authorities Bundle 3.
I think that should be right.
So Zuberi, is it?
Yes,
We
that's
seem
right.
to have got it
Twice.
Twice, I
thought
think.
it's at 19. In the reported form, it's at 19.
Yes, it is. I'm happy to work on either. I think it's. I think 19 was meant to be the High Court's judgment, but
No.
yeah.
Is that-
I work off tab 19.
Well, whichever you, we're only really concerned with the Court of Appeal, aren't we?
That's right.
Okay.
So maybe 20 if that's
Okay.
all right with your lordships. So the issue is summarised in paragraph 1, which I would invite your lordships to read.
Yeah.
So the contract of retainer there contained 2 relevant clauses. A clause that provided that in the event of success, the solicitors would be entitled to a share of recoveries. That was clause 9.1. And a clause which said that if the client terminated the agreement prematurely, which didn't in fact occur, she must pay the solicitor's normal fees and disbursements. That's clause 6.2. There was nothing wrong with the clause that provided that the solicitors would be entitled to a share of recoveries. That share was 12%, which was below the statutory cap. However, the issue was whether the premature termination provision, clause 6.2, was lawful in view of Regulation 4.1 of the DBA regs, which provided that a DBA must not require the payment of costs and disbursements. So the question before the court was a narrow one of which parts of the retainer were caught by Regulation 4 of the DBA regs. Lord Justice Lewison's analysis of that issue begins at paragraph 32, which is at page 870.
Sorry, paragraph.
32 at page 870. And over the page, he sets out the familiar definition of the DBA. At paragraph 33, he says there are two possible views of what the DBA consists of. One view is that if a contract of retainer contains any provision which entitles the lawyer to a share of recoveries, then the whole contract of retainer is a DBA. In other words, a DBA is a contract which includes a provision for sharing recoveries. But another view is that if the contract of retainer contains a provision which entitles the lawyer to a share of recoveries, but also contains other provisions which provide for payment on a different basis, or other terms which do not deal with payment at all, only those provisions in the contract of retainer which deal with payment out of recoveries amount to a DBA. At paragraph 34, Lord Justice Lewison stated that he preferred the latter view, that being consistent with the object of legislation and the fact that the common law did not preclude a contract of retainer without the DBA clause. So his conclusion is that clause 6.2, the premature termination provision, was not caught by Regulation 4 because it did not involve any payment out of recoveries at all. So it was not a DBA at all. The only clause that was caught by the regulations was the clause that provided for payment out of damages. He then provides reasons for that view by reference to the regulations. So at clause 36 in the first sentence, he says, the factual premise of Regulation 4 was that there were in fact recoveries available for sharing. At paragraph 37, he refers to other textual indications that Regulation 4 was only concerned with circumstances in which a recovery had been made. And at paragraph 42, at the bottom of the following page, he says, the regulation of the circumstances in which lawyers could recover their costs and expenses on termination of a DBA was not intended to be covered by the regulations and was to be left by their professional regulators. So the conclusion at 43 was that time costs, such as clause 6.2, were outside the scope of the regulations. And at paragraph 44, that the current regulations do not deal with lawyers' remunerations in the event that the client pursues a case to trial and loses. And the effect at paragraph 45 was that clause 6.2 was outside the scope of the regulations and its presence in the contract of retainer did not invalidate the contract. That was also the view of Lord Justice Coulson at paragraph 77, and Lord Justice Newey dissented on this issue. But critically, for present purposes, what the court was not concerned with is a situation where the clause that provided for payment out of recoveries, i.e. the DBA clause, was itself contrary to the DBA regs. So in Zuberi, there was nothing wrong with the DBA clause. It complied with the DBA regs. Nor was there anything wrong with the remainder of the contract, which did not make provision for payment out of damages. and was not otherwise enforceable as a matter of common law. By contrast, what we are concerned with here is a clause which does provide for payment out of recoveries and is a DBA and is therefore unenforceable by reason of section 47C(8). Where that is the case, we say the answer that is provided by the law of contract is to apply the doctrine of severance. That is evident, as I will come to show you, from the test for severance itself. Lord Justice Lewison also expressed opposite views that clause 6.2, so the premature payment provision clause, could be severed from the remainder of the contract at 7 and 8, paragraph 7 and 8. But those views were expressly obiter and he declined to consider the point, which is noted at paragraph 49. So the respondent's error, we say in their skeleton, is to conflate two distinct questions. First, which parts of the contract are caught by the DBA regulations? And second, the consequences that follow if one part of the contract that is caught by the regulations falls foul of them. It was the first question that was answered in Zuberi. The second question was not. That is a question of contract law governed by the rules of severance. So what my learned friends suggest is that the percentage payment provisions could remain in the contract but not be enforceable. Not only is that inconsistent with what the law of contract instructs, but it also cannot be correct. So take an example where a client agrees to pay a solicitor 70% of damages and makes no provision for other payment. That provision is unenforceable because it's contrary to the DBA regs. On my learned friend's case, that provision would be enforceable, but the remainder of the contract, which would require the solicitor to continue to undertake the work, but now, for free, would be. That is obviously grossly unfair and cannot be correct. The contract law solution, which we say is relevant here, is to ask whether the clause can be severed from the contract. It obviously could not be in the example I've just given, because its removal would fundamentally change the nature of the bargain between the parties. Turning now to my second topic, severance, please could I ask your lordships to turn up the key case, which is Volterra, and should be in the same bundle at tab 26,
Yeah.
page 1079.
Yeah.
The facts are at paragraphs 1 and 2. The solicitors that acted for the claimant under a CFA, the CFA was unenforceable. Sorry, that is at page 1082. The CFA was unenforceable because it had included a success fee that could exceed 100%, and it had not stated that success fee, and that was common ground. The CFA also included provision for solicitors to be paid on an hourly basis, but at a discounted rate of 70% of the fees. The relevant issue was whether the solicitors could sever the offending success fee provisions and recover the fees at a discounted rate. The discussion on severance begins at paragraph 16, which is at page 1086.
One
86. And could I I invite your lordships to read paragraph 17 and 18. So that describes the public policy basis that applies in relation to contingency fee agreements. And the public policy basis was the risk of conflicts of interest. The submission was then made that the public policy had changed and the court should recognise that change. The court dealt with that submission at paragraph 26. That's at page 1091. Could I invite your lordships to read that paragraph?
26.
Yes. So the court there concluded that Parliament had defined what the public policy was in the 1990 Act, and that any further modification of public policy was a matter for Parliament and not the courts. And they note there that that is relevant to considering severance. With that context, the court begins to consider severance at paragraph 27, and the three-stage test for severance is set out at paragraph 28. And here, could I invite you to note that it starts with a contract which contains an unenforceable provision nevertheless remains effective after the removal or severance of that provision if the following conditions are satisfied. And pausing there, that was the submission I made to your lordships earlier, that severance is the only solution where a provision of a contract is unenforceable. The court then sets out the three conditions. Like in Volterra, on our facts, we don't dispute that the first and second condition would be satisfied. The third condition was the focus of this case and this appeal, whether the removal of the unenforceable provision does not so change the character of the contract that it becomes not the sort of contract that the parties entered into at all. The court then proceeded to give guidance on the application of that test. There are three key points for present purposes. First, the exercise that the court undertakes is to compare the contract as a whole with and without the severed part, and to ask whether the contract as a whole after severance was of the same character as before. It doesn't look at only the remaining part, and that's in paragraphs 30 and 37. The fact that there are some provisions in common does not necessarily, or even probably, mean that severance should be permitted. That's at paragraph 38. Second, the court's focus is on substance and not on form. It must consider how radical the change is. And third, on the facts of the case, the test was not satisfied. The analysis in terms of application starts at paragraph 40, which is at page 1097. Here, the court observes in the first sentence that severance would fundamentally change the nature of the contract. Paragraph 41 records that the solicitors sought to rely on garnet trading and shipping to avoid that conclusion. In that case, the solicitors and client had entered into a retainer with provision for hourly payment. They then varied it to make provision for costs for work carried out in relation to the appeal. The court found that the varied bit was unenforceable because it didn't comply with section 58. At paragraph 44, the court explains why it rejected the analogy with that case. It says, the critical distinction is to be found at paragraph 28 of Garnett, which contemplates work being carried out after the date of the varied agreement, which did not fall within the scope of the variation because the variation applied only to the work on the appeal. Any other work and terms on which it was done were unaffected by the varied agreement, which gave rise to the CFA, but only applied to work done on the appeal. Once the blue pencil test was applied to the offending provisions in Garnett, which all related to the work done on the appeal and nothing else, the parties were left with the original retainer, which continued to govern all other work and was unchanged. And could I then invite your lordships to read paragraph 45?
Yeah.
The court the court distinguished Garnett on the basis that the offending provision in Volterra covered all work. If severance were permitted, the agreement in relation to all work carried out would be converted from being a CFA into an agreement for the payment on a conventional hourly basis. That was described as being the major change, with the result that the agreement was not of the sort of contract that the parties had entered into, i.e. a CFA at all. It is the change in the legal effect of the agreement that was described as being critical. And that is...
Is it the legal effect? I'm just
Yes.
interested. 45, I think, probably summarises what's set out in more detail in 40
Yes.
about the discounted rates and really the substantial economic impact of removing the clause
Yes.
on the solicitor's work. They'd have to do almost all the work at a substantially discounted rate, a reduced hourly rate, and that I think was the pith and substance of why they said it just wasn't the same agreement.
Yes, I think that is right. In this paragraph here, yes. But the critical part is that what it was before was a CFA, and now it's something else. It's a privately paying retainer, and that's in the last sentence. And that is also the same way in which the Supreme Court in Tillman describes the third stage of the test. I don't invite your lordships to turn it up, but the reference is paragraph 87, authorities bundle 1 at page 16. So here what they're saying is it was a CFA before, now it's not anymore. The court then proceeded to consider what it was, if it were wrong about the three-stage test, whether severance were permissible as a matter of public policy. And that starts at page 62. So public policy there is treated as a separate basis for not allowing severance. And the court says the principal effect of severance would be to permit partial enforcement of the unenforceable CFA. As was pointed out during submissions, if the client lost the arbitration, the effect of allowing severance would be that the solicitors would recover precisely the same amount of their fees as if the CFA had been held to be enforceable. That is, in my view, a tolerable outcome. The regime imposed by the 1990 Act is concerned with conflicts of interest giving rise to potential harm to clients. And we say, and I'll develop this submission, that the effect of severance would be the same with the Sony LFA. Can I now turn to the Sony LFA, which...
Is it a convenient moment to have a break? How long are you going to do?
Sorry?
You're not going to finish in 5 minutes, are you?
No.
No, let's have a break for 5 minutes.
Of course. All rise if able. I'm cutting out this bit, so I think
Or we've got like a nicely like an area. I haven't been there.
Subject to severance, so subject to severance. So assuming your severance fails, assuming no conditionality. You started off the thing with the percentage or
Yeah, well done.
What do you think? Big faces all around. Yeah. They gave me my very favorite example in the report.
Because of policy.
I actually think we're right. Oh, I Everyone has chilled out a little bit.
This is not fatalistic. It's kind of feeling by the time it gets to them, it'll be deadlines.
Usually we say.
I didn't delight in this.
Send for Richardson. He'll tell us all the answers.
Yeah, I know. Well, I actually hadn't remembered that until you took it, until you mentioned it when you wanted to.
Report rising table. I was just about to start my submissions on severance by reference to the Sony LFA. Which is it in the supplementary bundle, tab C3, and it starts at, sorry, it's not this,
Supplementary bundle
tab C3.
E3.
C3?
C3.
It starts at page 358, might be easier.
That's the easiest way to work it
Yeah.
out.
I will give you page reference.
Page
358.
358. Yeah, it only arises in this
That's
Neill
yes.
contract.
Yes. There is a similar provision in the CIC agreements, the opt-in priorities agreement, but the point hasn't been taken. And the funder's fee clause is at page 370.
Is that just so, sorry to interrupt you. Is it because, is the reason why it only arises in Neill because the other agreements haven't actually been signed?
The clause is in Neill and CIC. At the time this was before the tribunal, my understanding is that the clause was in draft form and it hadn't been signed. So the severance point wasn't taken. I don't know what the position is now. But yes. So the thinking was that it could be amended
Well,
before it was signed.
perhaps somebody could clarify that for us at some stage before the hearing ends, exactly what the status of these agreements is. Be helpful, I think. Okay, thank you.
So the funder's fee is at clause 11.
Yeah.
And you can see that there are two separate provisions, the calculation depending on whether it's paid from distributed or undistributed damages. Taking the first clause, clause 11.1, where the class representative makes an application for the payment of the funder's fee other than from undistributed damages, which my learned friend Mr. Pitchlin showed to you, the funder's fee is calculated as the greater of a multiple of the cost limit, or only to the extent enforceable and permitted by the applicable law, or a percentage of the proceeds. To sever the unenforceable provision, it would require the court to strike through the shall be greater of, clause 11.1.2, and amend the table referring to the payment of the funder's fee. Now we say that an amendment of that type would generate, as a matter of substance, a major change in the overall effect of the agreement. And we say that for three reasons. First, the effect would be to convert what is a DBA into an agreement for payment on different terms. There would be a change in the legal effect of the LFA. But that is not merely a technical point. The parties have chosen to include the percentage payment provision for a reason, and including it is advantageous to the funder. Severance would, like in the Volterra case, convert the LFA from a DBA to an agreement for payment on lesser terms. And we say that because clause 11.1 provides that you shall get the greater of 11.1.1 or 1.2. The fact that the LFA would, second, as a matter of substance involve a major change is apparent from a worked example of the application of clause 11.1. Now let's say, for the purposes of this example, that the application is made now. So that is, we're in the second row. So we're after 6 months from the CPA. So under the first limb, so the multiple, the funder would be entitled to 3.25 times the cost limit. The cost limit is defined as around 15.15 million. So the payment to which the funder would be entitled is approximately 50 million. Under the second limb, the funder would be entitled to 22% of the proceeds. We obviously don't have a number for that, but the class representative claims aggregate losses ranging between 0.6 billion and 5 billion, and that's in the re-amended claim form.
Yeah.
So even if we were to take the smaller of those figures, 600 million, applying this clause, the DBA clause, would entitle the funder to 132 million. That is almost 3 times what they would receive under the first limb. Of course, we accept that the amount of the proceeds in fact recovered may differ, but as a matter of substance, the incentives on the funder vary considerably. Third, like Volterra, we are concerned with the payment of a single fee, the funder's fee, which has been introduced in respect of the same consideration which has two components, the multiple or the DBA. The funder is entitled, if the conditional element of clause 11.1.2 is satisfied, to payment of the greater amount. This is not a case like Garnet, where the offending part makes provision for payment of a specific subset of work, with the other non-offending provisions for payment of other work. There is a single fee for the same consideration and a single mechanism for calculating that fee. We say, in addition, that severance would not be available as a matter of public policy, even if it were the case that the three-stage test in Tillman was satisfied. Public policy here is defined by the statute. For these purposes, for issue 3, unlike issue 1, the public policy is defined by reference to section 47C8. Parliament has placed restrictions on the extent to which lawyers and funders could be paid out of the sums recovered, and provided that DBAs of any type are unenforceable if they relate to opt-out claims by section 47C8. The public policy concerns here are reflected in the express terms of the rules.
Is this the same point that Mr. Pitchin made about incentives earlier?
Yes, that is correct, my lord. So the specific concern, as Mr. Pitchin took you to, was that allowing DBAs could encourage speculative litigation and create an incentive for lawyers to focus on only the largest cases. And Mr. Pitchin showed you the relevant parts of the government response. And those apply to funders as well, we submit. And here the statutory scheme prescribes the extent to which DBAs are not objectionable in different types of proceedings. So Parliament has decided that DBA is not permissible in opt-out collective proceedings, and that defines the public policy, and that answers the public policy question, we'd say.
I thought the public policy question was about lawyers rather than funders.
Well, the public policy question was about disincentivizing speculative litigation and encouraging focus on the largest cases, and we'd say they apply equally to funders as they do to lawyers. But in any event, you don't need to go there because the statute tells you what public policy is.
But might it be said that this is where we get into this slightly curious world where one might say that the policy that was underpinning this change in the law perhaps might be said to have assumed that funders weren't claim handlers, which is Packard now says, actually, you know what, you were wrong about that. But when the policy was laid down, the incentive wasn't about funders, it was about lawyers.
Well, we'd say those same incentives that were identified in the government consultation response apply equally to funders, in the sense that if you were entitled to a share of damages.
The point I'm trying to make, and forgive me if I'm not making it clear,
No.
genuinely, is that I thought the policy didn't mind funders having an incentive. The policy was never that funders couldn't have DBAs. That wasn't the point. The only reason we're here is because funders have turned out to be lawyers.
Well, the effect of the Supreme Court's conclusion in Packard is that provision, DBA provisions now apply to funding agreements as well. And we say that the statute defines what the public policy is in that case. So insofar as it's inconsistent with the statute, public policy couldn't dictate anything else.
Thank you.
I now wanted to turn briefly to the judgment below.
Can I just ask you about the difference between this contract and Volterra? In Volterra, the solicitors wrongly assumed that the contract they entered into with the client was lawful, and they would get the two limbs, the reduced hourly rate plus the uplift. In the present case, the funders enter into clause 11.1 and 2 upon the basis that the uplift is unlawful and unenforceable, and they only accept an uplift if the law changes. So if you sever this, isn't this still, on that premise, the sort of agreement that the funders would have entered?
Yes.
Because they did enter it on this basis. Namely that the Lim 2 uplift was, at the time of signing, unenforceable and unlawful.
I think this relates to my learned friend Mr. Pitchin's point about the incentives that apply as soon as you enter into agreement of this type. I mean, we must assume that it was included for some reason, otherwise it wouldn't have been included at all. And the law, as it currently stands, is that it is not enforceable, but that doesn't mean mean that you couldn't have incentives on the basis that it might be as a result of the CJC report, it might be as a result of
Understood,
others.
all of that's logical, but they still entered it, and the case may come to a conclusion before the law changes, and the CAT might make its final decision, its final order, and that'll be that. And they accepted that.
Yes.
So in those circumstances, can you say that with that clause 7, the contract is so changed that it's really not the sort of contract that would have been entered into in the first place by funders?
Well, our submission is yes, you can, because if you can enter into clauses of this contract of this type, and be motivated by the incentives that turn out that are resulting from clauses of this type, the fact that you don't at the end claim that amount is, we say, irrelevant. You have to judge the position now, and the position is that's an unenforceable DBA.
I mean, we understand the point. There's obviously an element of hope coupled to some degree of expectation.
Yes.
So we understand that. But it, as drafted, when they entered the agreement, they knew there was a real possibility you wouldn't get the uplift.
Yes.
So the question is whether the difference between the two is such that they wouldn't have entered it without this additional provision.
Well, look, I think the test though is not just whether they would have entered into it
No,
with
it's
or
a
without
question
this
of how
provision,
what
but it's
damage you do to the contract and
Yes.
the policy and so, yes.
yes, and it's also a question of public policy.
Understood.
It's not only a question of whether the third
Absolutely.
test of Tillman is satisfied, which is what I think, my lord, your question was
No, understood.
directed at.
Okay.
Now, could I turn to the judgment below?
You're looking at the judgment, are we?
Yes, briefly.
That's,
It's at core page 178.
yeah.
And the relevant part is at page 232.
Yeah.
And it's really the focus of it is at paragraph 152.
Yeah.
Where they refer to the severance clause. They say there's no major change in the overall effect of the LFA because there was a severance clause in the contract. The respondents also rely on the severance clause, which they say has a decisive impact on the outcome. We would say it's not decisive, and it's similar to the question my Lord Just Screen put to me. The clause would not permit the court to sever the offending provisions unless the test for severance, including and in particular the public policy test, is satisfied. And for that proposition, could I ask your lordships to turn up Monster Vision and McKee, which is in the supplementary authorities bundle. It's the first tab. It doesn't really matter for present purposes, but what it concerned was an application to continue an injunction relating to the enforceability of certain restrictive covenants. There was a severance clause, which is at page 40, which is page 14 of the bundle. Mr. Justice Sweeney found the non-competition clause to be unreasonable at paragraph 55, which is on page 17. On the following page, he then asked whether the clause was severable, so that's at paragraph 56. Can I invite your lordships to read paragraphs 56? key point is the endorsement of the point that such a clause can achieve no more than the court using its common law powers. The court then proceeds to set out the test for severance, including at paragraph 4, the public policy test. And so we say the public policy test is a fetter on the party's freedom to contract. It must be satisfied for the court to sever a provision, and we say it's not for the reasons that I've already given. Unless I can assist your lordships further, please.
No, thank you very much indeed.
Thank you.
May it please your lordships, I've got about 40 minutes or so just to outline, if I may, our position, and tomorrow I will.
I thought you were going to say you can finish at 40.
I might do that, but I won't. I will go into more of the weeds tomorrow, but there are some fundamental points which I'm eager to convey before we depart
But yeah, well,
this afternoon.
we'll, if you think you can do it in 40 minutes and that takes us beyond 4:15, that's fine. If you
Right.
think it's going to take, we can't really sit beyond 4:30. That's
No, I won't finish before. I won't
No,
go
no.
that long. I just wanted to use this moment to sort of articulate some key
No, I understand.
principles that
Yeah.
my lords can sleep on overnight.
Yeah, if you wish.
None of the points will result in nightmares. They will all result in happy
Well,
sleep.
you know, Mr. Bacon, I don't think
Um,
they might do.
I don't think they will. We began this morning with my learned friend submitting that this court should be cautious to ensure that it doesn't leave any, quotes, gaping wounds in the future in the approach that it takes to the resolution of the issue before you. And I'm clearly dealing with ground one at this point.
Yeah.
We submit that the effect of the learned friend's submissions would leave not gaping wounds, but I mean, that is an understatement to say the least. It would have the potential to leave unimaginable injury to the civil
You don't
justice
get
system.
nightmares.
which is why you will sleep happily tonight, because the answers
This is turning into a Netflix.
do not leave you with nightmares, I can assure you. But the point I make is that the submissions, when you take them to their logical conclusion, do result in quite extraordinary outcomes for the civil justice system. And it's a serious point. I know my lords have it. Unimaginable injury actually would be caused if it is the case, as it appears to be, that Parliament in 2013 and 2015 was legislating on the understanding that a DBA could also be a CFA. Parliament would be causing unimaginable injury if it thought that in 2015, when it legislated against the use of DBAs in the Competition Appeal Tribunal, that it was effectively closing the doors to any funded piece of litigation. Because the government knew at that stage that the only way in which to pursue opt-out proceedings was with the assistance of litigation funding. They're just two examples. The third can be attached respectively to the point that was made by my Lord Justice Burse regarding the common law position as regards what is and what is not lawful. The example given of the solicitor agreeing to look to the damages for payment on behalf of the impecunious client. That, too, on my learned friend's concession, would amount to a DBA. None of this makes any coherent sense. I mean that. It does not make any coherent sense. And the approach that we seek to develop does actually make complete coherent sense. That we shall demonstrate. I wanted to begin by just launching into the key issue of statutory interpretation. In my submission, the answer does lie in the Supreme Court's decision in Packard. This court is concerned with interpreting section 58 AA 3A2. Helpfully, in PACAR, Lord Sales addressed the effect of that provision and told us how we approach the interpretation of the clause. And the judgment is at page 1004, tab 25 of the authorities bundle, 2 of 2. My learned friend took you to this in the context of 2 passages referred to in the tribunal below, but I want to take you to PACAR itself. He took you to PACAR and took you through a number of paragraphs this morning. He didn't take you to 98 and 99. When doing that, he did it later on.
Yeah.
And he also didn't take you to 2 other key paragraphs, 43 and 45. And just before I launch into those, the case that is being articulated by my learned friend is very solidly founded on an assertion, a submission, that this court is not able to have regard to what Parliament thought of the litigation landscape and what it thought was the meaning of a CFA and what it thought or understood to be the meaning of a DBA in 2012, 2013 and 2015, that is all irrelevant because one has to only focus on what Parliament understood the meaning of a DBA to be in 2009, when the Coroners and Justice Act introduced DBAs. He's wrong about that. He seeks to say and assert this proposition by reference to PACAR, but PACAR was a completely different beast so far as statutory interpretation was concerned on the facts. PACAR was a case, as my lords know, but I just briefly articulate the point. PACAR was a case where the Supreme Court was being asked to interpret the meaning of the words claims management services. And they had been defined in 2006 by the Compensation Act. Parliament, when introducing claims management services into the remit of DBAs, cross-referred back to the 2006 definition. And it did so every time there was an amendment, and has been an amendment to the DBA legislation, both statutory provisions and subordinate legislation. And so one can see force in the argument that without more, Parliament was to be taken as assuming that it was defining claims management services by reference to the 2006 Act, not least because that's what the 2013 and 12 legislation said. That is how you define claims management services. So there was an obvious difficulty in the respondents in PACAR in persuading the Supreme Court that the 2012 and 13 amendments to the DBA legislation could be taken into account in determining what is meant by claims management services. The position here is mercifully different. In this case, we're looking at language which was introduced in 2009, that my learned friend and I are agreed on. But we're also able to look in 2012 and 2013 and 15 from 2012, which was the introduction of LASPO and the regulations in 2013, the DBA legislation, statutory and subordinate legislation, was subject to amendment. And it was a comprehensive series of amendments, not just to DBAs, but to other ways of funding litigation, including conditional fee agreements. Parliament was in 2012, 2013, dealing with the same subject matter that Parliament was dealing with in 2009. That's the difference with PACAR. In PACAR, the subject matter in 2006 was the regulation of claims management services in a separate statutory regime, the Compensation Act. And the DBA legislation borrowed a definition from that statutory regime. So there are two different statutory regimes involved. Here, Parliament is in 2012 concerned with the same subject matter as it was in 2009. And with respect, we say it is plain from the authorities, and indeed Lord Sales says as much, that of course Parliament, what Parliament thought in 2012 and 2013 when updating the DBA legislation, one is quite entitled to take into account what Parliament understood to be the meaning of a DBA in 2012-13 in interpreting the 2009 incarnation. And I'll turn to the authorities in more detail, but that's an important point to articulate at this early stage, because everything that my learned friend builds his bricks on does depend on us all evidently being confined to what Parliament might have thought in 2009 only. You get a little indication of this in PACCAR. There are other authorities which deal with it more substantively, but paragraphs 43 and 45, first of all, there are two paragraphs which my learned friend didn't take, no criticism, but he didn't take you to them when he helpfully took my lords through the well-understood approach to statutory interpretation. He didn't take you to 43. The courts will not interpret a statute so as to produce an absurd result, unless clearly constrained to do so by the words Parliament has used. And citing from Benyon, the court seeks to avoid a construction that produces an absurd result, since this is unlikely to have been intended by the legislator. As the authors of Benyon and Bailey and Norbury say, the courts give a wide meaning to absurdity in this context, quotes, using it to include virtually any result which is impossible, unworkable, impracticable, inconvenient, anomalous or illogical, futile or pointless, artificial or productive of a disproportionate counterstiff. That's point number one. The other aspect that my learned friend didn't take you to in PACCAR was paragraph 45. And this is about the coherence approach to statutory interpretation. In paragraph 45, Lord Sales was considering the effect of the 2006 Act, so that's the Act which introduced the Claims Management Services definition and the regulation of claims management services through the scope order. And he said indeed, given the broadly contemporaneous nature of the scope order, it can fairly be regarded as being in combination with the 2006 Act. Nobody would disagree with that. Part of a single scheme to introduce a new statutory regime in Part 2 in a way that justifies reference to the scope order to take account of indications of consistency between them. So just pausing there, when Parliament is legislating, one can take into account the subordinate legislation that's incepted at or around the same time. You can take that into account in assisting in the interpretation of the statutory provisions. Pretty obvious. At letter G, letter G halfway down, where the primary legislation and the subordinate legislation are drafted by or on the instructions of the same government department at about the same time, as would be normal in this type of case, it is reasonable to suppose they are inspired by the same underlying objective and are intended to reflect a coherent position as understood at the time the primary legislation is presented to Parliament. So this principle of coherency is a relevant factor too. And of course, we say that in 2012 and 2015, the 2015 aspect being the introduction of section 47C, the same government that introduced the amendments to the DBA regs in through LASPO, so widening the scope of DBAs to all proceedings beyond just employment tribunals. The same government was seeking to achieve plainly a coherent position between, on the one hand, the banning of DBAs in the Competition Appeal Tribunal, but the use of them in all other proceedings. That's one aspect of it. The effect of my learned friend submissions is that in 2012 and 2013, Parliament introduced amendments to the CFA legislation and the then existing DBA legislation, with the consequence that CFAs become DBAs, that funding that had historically and hitherto been entirely lawful, common law, became unlawful in the context of opt-out proceedings. And moreover, going to a more granular level, when solicitors and funders sought to respect the new Act, the Section 47C structured new CAT regime, which plainly anticipated that the damages would be used to discharge the stakeholders' entitlements, that by seeking to meet that objective, on the Learned Friends case, they render themselves, they are forced to enter into unenforceable agreements, which can't actually be deployed in the CAT, the very tribunal in which they've been seeking to meet the objectives of, which would be a completely illogical, incoherent approach to statutory construction. So that's 45. The answer, when one looks at how to approach the question of construction in 2009 and subsequently, is, as I say, we would submit, found conclusively, actually, in paragraph 99 of the Packard judgment. And I do submit that this is a clear answer to the question that my lords are grappling with. As my lords had indicated in the course of argument, in Packard, the respondents to the appeal were seeking to contend that the DBA that they'd entered into, because it was a percentage LFA, it was accepted that it was non-enforceable. It was a percentage arrangement which would otherwise be unenforceable. They sought to argue that the effect of the structure put in place by Section 47 in 2015, the structure of the CAT and the operation of its rules, was such that it meant that it was no longer a DBA because the final arbiter as to what was payable was the court, the tribunal. So they sought to argue that properly construing Section 58AA3A2, you must take account the words determined by reference to the damages is broad enough to include the discretion afforded to the tribunal, such that it's no longer such that it comes out of it. It's not determined by reference to the agreement, it's determined by reference to the CAT. And Lord Sales rejected that. And the important point about what Lord Sales did and why he rejected is key. He said the focus in determining whether or not an agreement is whether a return, a funding return or payment is determined by reference to the amount of the financial benefit so as to satisfy the condition in 58A3A2 is to identify the primary contractual entitlement. So in Yarcoom's case, the primary contractual entitlement, this is at the bottom of page 9, paragraph 99, the primary contractual entitlement in the LFA was a percentage payment. Yes, it was subject to ultimate determination by the tribunal because that's what the rules anticipate. But that didn't mean that the primary contractual entitlement wasn't still a percentage and therefore was a DBA, because the primary contractual entitlement in that case was a percentage, which clearly was, and by definition, a DBA. In our case, the primary contractual entitlement is not a percentage at all. It's got nothing to do with the level of the damages. The primary contractual entitlement that each of these funders have contracted for is a multiple of their capital funding, sometimes deployed, sometimes reserved funding. But either way, it's a multiple of the funding. It's got nothing to do with the damages at all. And if you apply this reasoning, as we submit you should, the fact that the multiple may be subject to some subsequent moderation by the tribunal, depending on the level of damages, depending on all sorts of factors actually that the tribunal may have in mind, does not alter the primary character of the primary contractual entitlement under the LFA. That is a complete answer with respect to this appeal. And in fairness to the tribunal below, particularly in the CICC case, it was the same tribunal in Neill, that is basically what the tribunal was saying. You were taken to the two paragraphs earlier today. The other important aspect of PACAR is paragraph 98, whilst we're still on the same page. Under the opt-out LFA, Yarcoom's funder's fee is expressed to include a percentage of the proceeds of the litigation. As the appellants point out, and that's effectively the same appellants that are here, the appellants point out, according to the procedural rules in the tribunal, and by virtue of the Competition Act 1998, the funder of opt-out proceedings always takes the risk that all of the damages recovered will be distributed to members of the class, with the result that there will be nothing left to pay its fee. And this is important. This is the Supreme Court recognising that in all cases, it's the proceeds that are utilised to discharge the stakeholders' entitlements. There's no parliamentary debate, discussion, anything suggesting that a class representative bringing opt-out proceedings should be required to expose themselves personally to liabilities of the kind which learned friend is saying they ought to do in order to bring a claim in the CAT. Quite the contrary. And the importance of this is clear. If it is the case, and we say mercifully it is, that the CAT, the structure that Parliament imposed in 2015 in introducing Section 47C, was the expectation that the damages would be the source from which payment would be made for stakeholders. And we have a number of parliamentary statements from ministers. It's very clear from the consultation process that it was essential to bring opt-out proceedings, that funders be permitted to fund the cases. Then it is obvious that it can't be said that a funder that says I'm going to charge a multiple by way of return, not subject to the damages, but of course I'm going to limit the sum that I charge to whatever the statutory regime permits, namely the damages, because that's how it works, that somehow that brings them into a DBA and they're unenforceable, with the result that the funder can't fund the case. I mean, it is completely incoherent, this submission. It leads to absurdity, where a funder is seeking to meet the objectives of the Act, the requirements of the Act, that in all cases the damages will be a limit, by by recognising that limit in the LFA, on my learner friend's case, they convert what would otherwise not been a DBA into a DBA, rendering the agreement unenforceable in the CAT. It is an extraordinary proposition, and it's one that the court simply doesn't
Especially
need
since
to go to a
many
close
of
to.
these cases are opt-out cases.
Yes.
I'm true it is that there are opt-in cases in the collective proceedings regime, but I think the bulk of the cases, certainly the ones that have come to this court, have been opt-out.
Yes. Absolutely.
Precisely because, I mean, if you take things like the MIF cases,
Yes.
precisely because the amount that the individual any individual claims are going to get is, you know, whatever it is, £45 or whatever.
So the beauty,
Nobody, I forget whether it's an American judge, I think, who said nobody's going to sue for $30.
nobody, no, quite. The beauty of the argument which we seek to impress upon the court is that whether it's opt-in or opt-out, if the LFA is charged for a multiple, it's simply not a DBA. And that, with respect, does reflect the pre-existing common law position, where the courts have accepted cases like Arkin. We know them. The courts are familiar with them. Factor tame. That funding of litigation is lawful, not unlawful. And yet, on my learner friend's interpretation, it's made unlawful in the very proceedings in which the government has said publicly in all of its consultation that without funders, this scheme won't work. And so, get further down the page in paragraph 98, where Lord Sells speaks of the mechanism. It's a helpful way of referring to this aspect of the LFAs. The terms of the opt-out LFA, reading from letter E, the terms of the opt-out LFA between UKTC and Yarkoub are structured to take this mechanism into account. Namely, the mechanism that the tribunal will be the final arbiter as to how the damages are to be distributed. And so what you see in all of these agreements, there are different ways of achieving it, but they all, as my Lord the Lord Chancellor observed early on, they all broadly seek to do the same thing, which is to create a contractual liability to pay a multiple, but impose obligations on the class representative to seek an order from the tribunal for the damages to be distributed in such a way that it recompenses the funder. That's all that these agreements really do. The primary contractual entitlement is to a multiple of funding. And as I say, by reflecting in the LFAs the mechanism that everybody knows is required in these opt-out cases, the idea that that mechanism results in the agreement being unenforceable so that you can't even get before the CAT is extraordinary. The effect of it cannot be underestimated.
Yeah.
I think that's probably an appropriate moment to pause at this point. I can move on to the detail.
Not going to be in any shortage of time tomorrow.
I will be probably shorter than I expected to be tomorrow.
Okay, all right. 10:30 tomorrow morning.
Thank you.
All rise, approval.